Hello and welcome to everyone as you enter the Zoom webinar. We'll just give it a minute or two for everyone to have a chance to enter the room. So we'll just give this a minute or two. Welcome to everyone as you're entering the room. I've just got two hands up, Ashraf and David. If you've got, and Karen, if you've got questions to ask, if you just type your question into the chat facility and I can respond to you. Okay, good morning. Yeah. Okay, looks like our numbers have steadied out now, so we can make a start. It's my absolute pleasure to welcome along Martin Nally, who heads up the AB Phillips HR Advice Anywhere division. And as you know, we have a relationship with them in relation to providing HR advice to our members for a subscription fee. But without further ado, I'll hand you over to Martin, who's just going to have a general discussion with you today about all matters HR advice. I am recording this session and I'll be sharing it with all registrants when the recording is finalised in a day or two. And please ask any questions via the chat facility and I'll hand those on to Martin as we go along. Over to you, Martin.
Okay, well, good afternoon, everybody, and thanks very much for this opportunity. So we've done some roadshows with Rochelle, so some of you may have been in attendance to those roadshows, which talked about some specific things and more general issues about the advice that you provide. And so I do understand that you are all in a position of being advisors, you're transactors, you're probably coaches, you're problem solvers, and you are dealing with things on a day-to-day basis. And it's a myriad of things. I completely understand and respect that. And I suppose the approach that I'd like to take is to sort of really simplify some particular areas and have some discussions about this. Now, we may not cover all sorts of issues today in this first instance. I think we've probably got about 45 minutes to go through and I'll go through some various topics, but we can do these on a regular basis to keep you well informed. Additionally, we also have some regular communications that we send out from our organisation, AB Phillips, to the AAT subscribers. So subscribers get information, I suppose, a little bit more detailed than our regular members. So if you do subscribe to the service, then you're able to not only access this type of information on a information basis, but you're also able to ring and call us on particular issues. Now, a couple of things that I did emphasise when we mentioned, when we spoke with people on the roadshow, is that documentation of what you do is absolutely critical. And you are in that privileged position of being an advisor. And in actual fact, I don't say that lightly. I really feel privileged to be able to deal with a whole series of clients and for them to seek my advice, and hopefully you have that same mental model that you would feel privileged to be providing your clients with really good advice to take the pressure off them and allow them to do what they do really, really well. But in doing that and taking on that privilege, you really need to make sure that you don't take on risk. And so documentation is something that I mentioned, and we joked about the fact that how many times I said the word documentation in a presentation, but it's really critical to ensure that the advice that you give is based upon good sound evidentiary proof and data that you've researched, but also that you're making a record of the information that you are providing to your clients as well. They then hopefully will rely on that. It's interesting though, in terms of saying, well, what do you do when they don't want to rely on your information and they instruct you to do something else? that's where I think documentation is even more important, that you are actually being instructed to do something which you perhaps have advised against or are unsure of. In those instances, we can probably take some of the indemnity for you by providing you with some guidance. And if you were actually able to say, well, look, we've actually sought some advice on this and the advice says this, then it mitigates the risk for you in the advisory processes that you're putting forward. And I say that for a number of reasons, and I'm not going to get into all sorts of issues. I'm going to touch on sanctions just to give you some case studies later on in the session. But it is really important for advisors, which you are, to provide really well-grounded advice, and you can mitigate the risk for you and therefore be indemnified if you've sought expert opinion on things from time to time. And I've gave some examples in presentations I've recently made about various occasions where expert advice was sought and then there was an issue, some sort of complaint was actually lodged, and the advisor was found to be not responsible because they'd sought advice, given advice, and then the individuals didn't take that advice. So it really sheets it home to the individual client in that regard as well. So the types of things that we're going to talk about today revolve around the advice that you are giving to your clients. The first thing that I want to talk about, and I'll go through them quickly in order, is that we want to talk about how do you ensure your clients are not paying the wrong wages. And so it's really important for you to be aware of that. Secondly, we're going to talk, the second topic we're going to talk about is sanctions for underpayments. So where people are paying the incorrect thing, and there is a bit of a push at the moment to address that. Underneath that is the third topic, talking about the vulnerable workers situation. And so we really need to be aware of the fact that are your clients in a situation where they may or may not be involved with engaging people who are regarded as, in inverted commas, vulnerable. And then related to that as well, a bit of a subset is, do any of your clients actually have interns or work experience students? Because there's some common misconceptions about that process at the moment as well. In future sessions, we'll talk about casualisation, we'll talk about modifications to the Fair Work Act, we'll talk about some other payroll issues going forward, and we'll talk about even some prospects of what happens if there's a change of government. So we'll be talking about those types of issues into the future. But for today, I'd like to talk about those four topics. And if we've got some time at the end, we can address some specific questions. So to start off with, in terms of the notion of payment, are you paying? Are your clients paying the employees correctly? Last year in June, the Fair Work Commission announced that there were certain adjustments to the minimum wage, and they'll do that on a regular basis, and they're effective from most likely 1 July each year. So that may occur again this year. And the Fair Work Commission has handed down these minimum wage reviews. I would think that irrespective of the change of government that may or may not occur, that most likely will be something that would be sorted out. The Fair Work Act is most likely not going to be changed. After all, it was brought in by Labor governments in the past, so it's most likely going to remain. And so therefore there were some increases that were lodged of about 3.5%. So the minimum wage for adults is $719.20, so it's effective from the 1st of July. Now, it's an ideal time to ensure that your business is meeting that in the lead up to the next one, because if you haven't got the one last year, it'll come through again, and we need to make sure that your people are correctly paid.
I've just got a question from Suzanne.
Mm-hmm.
And she's asking, in an employment letter, can you state that during a probation period you can be terminated with 1 day notice? And it's the retail award.
Well, look, I'm not going to be able to reference every award today. The minimum standard is that see, for instance, probation is not even a thing in the Fair Work Act. It's actually a common law construct. There is a situation, though, where people are 1 day notice is not the case. It's 1 week's notice would be the national standard. And the issue that you have there is that you don't have to have a very good reason. You just have to have a process whereby you're communicating fairly that in actual fact the person's probation is not going to be completed, and you have to give them a week's notice. Now, a week's notice is interesting because notice doesn't have to be paid. it can be actually given as actual notice. However, if you want the person to leave immediately, then you have to pay that in lieu. So my understanding is that the minimum standard is that under the National Employment Standards of the Fair Work Act, and there are 10, one of those minimum standards is that, one of the provisions is that there is a process whereby individuals are, who are employed by an organisation with more than 15 people and have had a minimum of 6 months employment can in actual fact therefore claim unfair dismissal if they're terminated. If, however, they've got more than 15 people and they've had less than 6 months service and they've been, even if that the probation wasn't mentioned in the letter, they can be terminated, and the individual has no right. That is, if they've got less than 6 months service, they've got no right to claim unfair dismissal. Now, so many clients of ours don't really comprehend what that means. They don't include it in the letter. They leave it till after 6 months, and then they come to us and say, we want to actually move this person on. I've actually put that very nicely. They oftentimes say different things, and they then say, well, what can I do? Well, they've actually removed the right for themselves to act within that 1 week, and they then have to work through a process, and the person is then available to that employee, or the opportunity is available for them to claim unfair dismissal. So I would recommend that in letters you do use the 6 month probation. I would strongly recommend that. It's not a provision of the Fair Work, but the minimum employment term of 6 months is. So we can commonly call that probation. If you do so, you can actually terminate someone with 1 week's notice. Does that answer the question?
Just can't see anything else from Anna at the moment, Martin, but I'll let you know if anything else comes through. Yes,
okay.
Thanks.
Okay, so the issue is that I would strongly recommend that all of you review your contracts. Let's just talk about that for a moment, because we've sort of kind of gone off, but it's only a cul-de-sac. We haven't gone off track completely. So in that situation, I would really strongly recommend that when you are appointing people, and if some of you are in the process of actually helping people write their letters of appointment, let's just cover that for a moment. There are a couple of issues that are really important. The first thing is that if someone's under an award, they don't need a contract. Now, that may seem self-evident, but I can tell you now that the majority of people out there give people contracts when they don't need them. If someone's under an award and an employer is paying to the award, they don't need to specify all of the conditions. They can simply reference the award. In that situation, I would recommend that people go given a letter of employment. And it's just a straight out letter. And with that, though, there is a legal requirement for the employer, and therefore you on their behalf, to provide a copy of the 10 National Employment Standards. They're freely available on the and up-to-date versions. PDF versions are freely available on the Fair Work site. And what I'll do after today is we'll actually do a bit of a summary of these comments and ideas, and we'll send that to you via Rochelle. The interesting thing about that, though, is that I would say a very high proportion of employees are not provided with that National Employment Standards requirement. There are 10 National Employment Standards. The 10th one is that you have to tell everyone that there are 10. So it's kind of an odd quirk of the law. I'm sure some bureaucrat said, let's put a 10th one in there and make it that we have to tell everyone that there are 10. I always find that quite amusing. But anyway, there's a requirement for people to be advised that that there are 10 National Employment Standards. So you don't need a contract if you've got an award. You don't need a contract if you've got an EBA. If you don't have an EBA and you don't have an award that you're referencing and they are above the award, then you do need a contract. What I did observe recently was that a large employer who has a nexus to an award, which means that it's got a connection, but it's paying above the award, actually gave someone an employment contract, and they included all their policies, all of their vision statements, their business plans, and everything in the contract. Now, that's very dangerous, and it's very unwise to do, because we've just contracted a person at law that they will operate under those conditions. What I would recommend is that you don't do that. You simplify things. If there's an award, give a letter of employment with the basics in it. If there's not an award, give a contract that reference that there are policies, there are standards, there are business requirements, and there are focus areas, etc., that are to be adhered to, that can be accessed within the company and will vary from time to time. That then contracts the individual to whatever the circumstances are of the day, and that's a very important consideration to make. I hope that makes sense.
Anne's just asked, Martin, what if you're paid under an award, but for example...
Under an award, yep.
Sorry, I've got some construction work going on beside me. What if you were paid under the award, but for example, allowances, etc., are included in a salary?
Look, you're getting very specific now, and it's really hard to answer every specific question. But what I would say to you is that you can have an access to the award, and so that you could then say in an employment contract, you would probably have a in-between step. It wouldn't be a full contract, and it wouldn't be just a basic letter. You'd have a letter which said you are covered for the normal circumstances under the award, however, and they are as a minimum, because what we know is that all of the provisions in the awards that we refer to are minimum standards. If you pay above that, the specifications above that need to be outlined in the letter. Does that answer the question? Hopefully it does. Are we still online?
Yes, thank you for that. Anne's just said thank you.
Okay. So the issue is that I suppose my answer to all of this is that there is no cookie cutter. The circumstances of each situation need to be reviewed and carefully examined. However, I don't believe in complications either. So therefore, if we've got people on an award and they're pretty stock standard, don't give them a contract, give them a letter, reference the award. The award must be visible, but the award does not have to be provided physically, but a location where the award is housed, filed, or available must be provided to the individual so that they can reference that. Every organisation like that, even for instance Coles Myer, with their 190,000 people, they have to make things available to people. They actually operate to an EBA. It's pretty much the retail award anyway. So the circumstances are that you've got an opportunity to engage with people, to clarify, to simplify. Don't go over the top, you don't need to, but look at the circumstances. And if they vary, it needs variation. If they are above the award and there are different circumstances and we're contracting people to do things differently, then most likely would be required to have a contract. Even contracts can be quite simplified, so we don't have to. I have an expression, don't wear a ball gown to a barbecue. So hopefully you'll understand that metaphor. Don't overcomplicate things. Do things really nicely, really simply, and appropriate to your client's needs. The other interesting thing too is that I do believe, though, that we actually have a fairly standardised system. So now, since 2009, in the last 10 years, we've reduced and simplified, and you'll know this, I'm sure, but there were 4,365 awards. Now there's 122. And there's a series of national employment standards that applies to all. So hence we've got a high cost of labour that's regulated, and in actual fact it's really simplified. So we shouldn't really get ourselves into too much difficulty at all. Now in terms, go ahead. Yep.
I've just got a query, just wanting to clarify your point that if we're under an award, there is no need for a contract and a letter will suffice.
That's correct. Because if you start to list everything down in the letter that's already there, number one, you're replicating what's in the award anyway, so why would you bother? So you're complicating things. Number two, you may misstate things, so therefore you're going to be locking yourself into a contracted arrangement that's above and beyond the award. The variations where someone's paid above the award, there should be a variation letter which is there, but you can say substandardly your conditions of employment are covered by the award and you are XYZ classification, and that may change from time to time depending upon the role that you're actually assigned to. There are some variations to that. In addition, you are eligible for these, and so that's the pathway that I would go. I wouldn't start to say just because there's a variation to the award, you give them a full-blown contract. However, if there is a situation where people are paid into a managerial role, they're not actually covered by the award and you don't want them to, then you can actually put a contract in place. That too can be quite simplified, but in those circumstances, you put a contract in place. Does that answer the question?
I think that's good. Thank you.
Okay, so minimum rates of pay are highly regulated in Australia, as I've said, and the modern awards and the Fair Work Commission really give us some guidance with regard to that. But they're minimum rates of pay, and after all, they are minimum rates of pay. So in actual fact, the best organisations in Australia don't necessarily just pay the minimum; they actually work out what they can afford, and they go through the process from there. So there are several key areas where we would ensure that employees are paid properly, and those actions would be, really becoming familiar with the National Employment Standards. So do that, and I can send you a one-page summary of that as well. But there is a link that we can provide for that to you, which actually outlines what the employment standards are. Finding out the relevant modern award that applies to the industry and all the roles that your employees or your employees of your client are actually engaged in, and becoming familiar with that is really important. But the issue too is that you don't necessarily have to be an expert in the award, because you can always ask someone and get some guidance from that. And there are some nuances and there are some redefinitions that need to be done from time to time, and applications of particular issues. So we've not simplified it so far that it's not a little bit complicated, but it's actually able to be determined in terms of the circumstances that exist. Determining the correct rates of pay that apply to various roles and classifications is really important. And then if there's an enterprise agreement that applies, we have to become familiar with that. And there's a concept called BOOT, B-O-O-T, you probably come across that, and that is that if we have an enterprise agreement, no longer is it acceptable to say that terms are no less favourable. The terms actually have to be better off overall. So there is a BOOT, it's the better off overall test. So if we engage our employees under an EBA, we have to be able to demonstrate to the Fair Work Commissioner that the terms that we're engaging are actually better off overall. So it's above the minimum on every standard that you vary. And so there has to be some really good reason why you actually move away from the modernised award. I would suggest that a large number of our clients are really comfortable utilising modernised award rather than going down an arduous EBA process. There has to be a very good reason to enable people to improve productivity or output or do things differently to actually go down the path of a enterprise bargaining agreement right now.
So Martin, we've got two more questions that have come in.
Mm-hmm.
Teresa has said that she currently processes wages based on the information given to her, included in the award, the rate per hour, overtime hours, and she processes that information through the ERP system, and it calculates the PAYG and super. She's advised the client to speak with Fair Work on the rates and know what award is applicable, because she can't know exactly what work is being completed by the employees. I'm wondering if she can be still held liable for some reason if they were found not to be paying correctly.
And the answer is absolutely yes.
So your advice would be for her to seek direction from experts such as yourself about those applicable rates and awards, etc.?
Well, I wouldn't, from an expert, of course, we're one of those. Of course, we could help, Rochelle, no question at all. But the issue that there is under Section 550 of the Fair Work Act, a thing called accessorial liability. And if you did attend any of the roadshows that Rochelle put on, and we will touch on that in the future roadshows as well, accessorial liability is really being pursued, and 92% of complaints that were made towards the concept of incorrect wages to the Fair Work Commission in the last 12 months actually involved an accessory. An accessory is someone defined by the Act as someone who knowingly or by omission or through lack of knowledge assists and provides guidance to the payment of or provision of benefits to employees directly or indirectly. And in that regard, the issue is that if you simply say, well, I'm only doing what I was told, if you actually find out that through a set of omission that, well, I've just been processing and they're wrong, then you can be held liable as an accessory. And so there are, and look, I'm not going to go down the path of all the fines that exist because they are substantial, but what I would suggest you do is you need to make that call. Previously, I mentioned the concept of calling an expert before you are required to do so. And I can give you many, many examples where an advisor such as you contacted an expert in this field, got advice, provided that advice to the client, and then the client instructed them not to follow that advice, to follow the original advice that they'd given, and therefore they were a party to employees being underpaid. What was found in a number of instances was that there was greater liability for the client, there was partial liability for the advisor, but they were almost like a slap on the wrist because they'd gone to the effort of getting the answer, pushing forward, and then them being told. It didn't remove the risk, but it significantly reduced the risk because of that piece. Now, I can't guarantee the circumstances because I don't know what the circumstances are, but I am going to give you strong counsel that at the point of you being unsure, if you don't get expert advice and pass that back on to the client, then that's a foolhardy process. In one instance where I was involved, we had an expert involved and the employees went out on strike. So there was, after, let's just say, a day, the matter was resolved and the employees were told that it was going to be resolved. But the employees then went out on strike for 5 weeks. When it went to the commission actually awarded the employees payment for only the day, because they then said the 5 weeks that you chose to go out on strike was a foolhardy exercise because you had been advised that an expert had given you counsel that things had now been fixed, but you chose to ignore that. The same type of thing and principle would apply to you. If you found out that something was amiss and then went and researched it and got expert advice, then advised your client of that expert advice, you could mitigate the risk to you individually, mitigate, I'm saying, not remove, but at least reduce, on the basis that you've given them and then they've instructed you. Now, I've mentioned the word documentation several times. Again, it's all a question of you having really good records about what you do, and that'll be able to protect you. Now, the other thing too is if you get expert advice and you follow it and it's found to be erroneous, then you're covered by the experts in indemnity insurance. You don't have to worry about your own. So there's lots of reasons why you shouldn't just process. You actually have to make sure that you're aware, and claiming that you're unaware is ignorance is not a defence of law. Now, it's a long-winded answer, but hopefully, does that make sense?
That does, thank you. We've got an additional question added to the question about the letter of employment replacing the contract. And this attendee would like to know if the letter to the employee can be treated as a legal documentation, like a contract, if there is any issue with the employee.
Oh, absolutely, no question. All of those things they're agreements, they're contracts, and they're looking at the terms. And if, for instance, someone's getting employed under an award and they also get a letter, it's an adjunct to. It sits alongside. It has equal weight. So the award conditions apply, and then the conditions outlined in the letter apply. There is a contractual employment agreement between the parties, and it doesn't have to be a contract because the terms of the contract would be, terms of the employment contract would be covered by the award. So if you like, you've got these, let's say we've got 3 categories. One, you've got an award-based employee, and they get a letter of appointment. That letter of appointment sets out the time, the processes, and in fact the award applies. Secondly, we've got an award employee, but there are some variations. So they get a letter of appointment plus they get an additional terms in the agreement. And third, you would have a contract, which would include all of the terms of the common law contract and would not necessarily reference the award because all the conditions would be above the award or salary, if you like. And so we've got this award-based, agreement-based, variation-based, or straight salary. And you know that. I hope I'm not trying to tends to suck eggs, but that they're the things that I just like to reinforce. Now, within that, there's part-time, there's fixed term, there's casual, then there's permanent, and there's full-time. So there's a whole series of different variations with regard to that. And once we understand that process, we can really clear, okay, let's go down.
Fantastic. I'm not entirely sure I understand this question, but let's read it out anyway. OTE.
Yep. Ordinary time earnings. Yep.
Yep. Is it reasonable not to pay super on overtime? Is there any unknown traps that can be overlooked?
Look, that's probably a really specific one related to the circumstances of the individual. So there are some issues whereby, for instance, the superannuation regulations are quite clear. The interesting one recently we had was with regard to casuals, and people were actually had to earn more than $450 a week before they attract superannuation for casuals. But the issue is that you actually are. It depends whether it's systemic and regular overtime. So if it's irregular, so what I would suggest that one would really need to look at the circumstances of that particular case and apply the superannuation guarantee legislation to that. But I'm more than happy to actually address that in the paragraph. We're going to run out of time with regard to that particular issue. I'm more than happy to address that and send that as a response in writing. So what we might do is we might sort of make a note of these. I know you've taped them. We might do a frequently asked question process so we can reference the exact circumstances and give you a couple of examples of that, if that would be, if that's appropriate.
That sounds fantastic, Martin.
So the frequently asked FAQ as a result of this would be quite a good idea, and then you've got some guidance along those lines. Now, in relation to what I was talking about, the payment of wages, just to cover that one off because I want to cover a couple of the other things off before we run out of time. The most information is actually available on the website and through Fair Work. Minimum wages are referred to. There's a guide. We'll include that in the link. Agreements are there. You have to reference those dependent upon the client. So that really will be up for you to make sure that they're up to date and they're actually. I would also check whether they're certified because we've had some examples where the employers said, "Oh yeah, we've got an agreement in place," and given it to their advisor, and actually it was never countenanced by the commission. So they're actually in breach. So just be careful that it has been certified as well. And of course, we could always look at the award list of awards on the Fair Work site, and we send you a link for that as well. We do so because we think that we can provide this information, but that's not to say that you need to be an expert. So we're more than happy to actually be called up and say, look, we're looking at this award and it says this here. What do you think? So you don't actually necessarily have to be an expert in these areas. We can give you some advice and go through the process from there. Salary payments, of course, are slightly different to that. And obviously there's an agreement about the amount of pay and the amount of work over a period of time, and it's annualised, obviously. I've had some experience whereby we've had people on very strong awards in the mining industry, and we've put them on an annualised salary and incorporated some overtime processes, and it was amazing what that could do because it actually drove the right behaviour. So instead of people having to stay back and work overtime to get work done that they really should have done, there was an incentive then to put them on salary to say, if you can get that done in your normal hours, you don't have to work the overtime to earn the dollars. Two reasons why that was really valuable. The first reason was that it reduced the risk because people were there less time. That was number one. The attraction of it for the employees was that we had a situation where the employees then could go to the actual bank and say that my salary is this. Previously, their base earnings was all that could be referred to, and overtime earnings weren't regular and systemic, and so they couldn't actually be getting bank loans based upon their actual earnings. By putting them on an annualised salary, they could, and it was an incredible attraction for them. So we had this wonderful increase in productivity, which completely outstripped the extra cost because the overtime dollars came down, their base earnings went up, the amount of time that they needed to earn that reduced, and interestingly enough, the productivity went up as well. This was in mining setting as well. So there are some things that you can do. There's a second example that I often refer to, and that's in relation to casualised nurses. And we had a situation with one with one particular organisation where there are a lot of casualised workers, and instead of them being given the opportunity to transfer to from casual to full-time or part-time, we changed and introduced the EBA a flexi worker classification. So there was a 2-hour minimum start and an 8-hour minimum start. There was a 10% loading or 25% loading. There was annual leave, long service leave, but no personal leave, and they were regarded as a flexi worker, and that was agreed by the unions. Again, one of the incredible attractions to that was that these people were no longer casuals, but they still had some flexibility, and they again could go to the bank and get a good loan. So there's all sorts of things about looking at the negotiation between the parties and finding the interests of both parties and achieving some outcomes which actually satisfy the interests of all parties, so not just the employer. Just quickly then, in relation to payment conditions, there are some things and tools that exist, and we'll send you some information about PACT, which is the payment conditions tool. You may have come across that before, but we'll give you a link to that as well. So you'll get a lot of the tools and templates that you can use. Again, we're not expecting you to be expert in this area, but there are some really good resources that are available that we can then collect them all for you and send them through for you as well. The Fair Work Ombudsman really focuses on compliance, though, and that's your role, is to make sure that we are achieving compliance with our clients, and that is your role. And as we've mentioned under the Section 550 of accessorial liability, there is some really important responsibility that comes to people who are advisors, and that would be you, in relation to the correct payment of wages. You can mitigate your risk by, remember, researching. Secondly, getting expert advice. Thirdly, documentation. That's really important.
Martin, Kerry wants to know that if the client records the wages and calculates all related withholdings, etc., in a pay book and pays the employee, and she's just recording it physically into the accounting software, could she still be deemed liable?
Look, it's probably less liability, but you know, what it really worries me is when people use the word just. But I just, and I've found that when people say just, it's sometimes an indication of the fact that, well, they still are involved. If, for instance, a court of competent jurisdiction could say, well, you are the bookkeeper, you are the accountant, you are the advisor, and Freddie the blind minder could have seen that that was actually incorrect, then you can be liable by a single omission. So if it's really obvious that these rates are, and what they're saying is, okay, is this the only client you've got? No. Are these the only wages you pay? No. Is there a circumstance? So there's a whole series of tests that we go through, and so liability could be still proven that you were an accessory. Now, the fines for accessory are still substantial, but they're not as much as the primary person who's liable. But you know what? As I said to you in the presentations of the roadshow, it's not about the fine. It's about the reputation of this. And if you're involved in something and it's a little bit dodgy, then you'll get a poor reputation. And none of us, look, I think that we're really fortunate with the members of AAT that people who are willing to do that are wanting to do the right thing. So that's great. And I've certainly got a tremendous sense of the great spirit that exists and the camaraderie and the wonderful community of practice that exists within AAT, because you all want to help each other and other thank you competitors. But don't take the risk. If it doesn't smell right, it isn't right. If it doesn't smell right, it isn't right. Even although you're just processing, you are an accessory. Effectively, you're driving a getaway car.
Okay, thank you for that. And Joanna's said that she has referred her client on to a third-party HR advice specialist, and the client's taken on the advice, and the pay rates, let's say, is under the minimum wage. Could I still be held liable with the client? Is that the same sort of response to the one you just gave? Yeah,
you do. We are reducing the liability there because there's an expert involvement. So there's, in actual fact, a lot of responsibility is shifted to that person. So again, we're actually we're spreading out the risk, and so the risk would be borne mainly by the client, to a greater degree by the advisor, and to a lesser degree by the processor. But again, you still got the getaway car.
Okay. Thank you. Terry has asked whether her client with leave loading for employees can actually pay that out spread over the year rather than when the leave is actually taken.
Look, it does depend upon the wording of the award or the agreement, so I can't answer that with surety because I don't know the circumstances, but I can answer this on the basis that yes, that is a possibility. In actual fact, a lot of people are actually paying that out, and so for instance, if you've got a mix of salary and award people, they're actually saying to the salary people, look, let's include, whatever it is, 2.5% value of the 7.5% over 4 weeks equates to about 2.5% or thereabouts. Let's just increase your salary like that because at the end of the day, it's not inflation. It is what it is type of thing. So it's less transaction. So the answer to the question is if it's contained within the award or it is possible to do that. The other thing too is that it's with agreement. It depends upon the size of the organisation. You can work through processes such as that. I'm all about reducing transactions. So I've had a colleague of mine who was a salaried employee all his life. He's got a particular organisation. And they pay fortnightly. Well, he's been paid monthly all his life. Now he's going to be paid fortnightly. And he can't understand why the organisation would pay fortnightly because it's twice the transactions that occur. Look, it's a quirk of the organisation and they do that. I'm all for minimising transactions. So if we can actually have that one less thing to do and it can be done by agreement, I'd be aiming to negotiate that. Look at the award, look at the agreement. If you're unsure, it's a call. But basically, if you can remove things like that and just say, let's just incorporate that into it, it's one less thing that you've got to administer. Just on the basis of administration, I know this is a bit of a flight of fantasy on my part, but it just occurred to me that one other thing that you should try and avoid your clients do is pay time off in lieu. Because time off in lieu to me is, it's actually a cop-out. People are working in times that they shouldn't be working, so they're to avoid payment for those times they give people time off in lieu. My experience is that time off in lieu just builds as a bank, and you've got to pay it out anyway. Then you've got to have an argument. Oh, well, hang on. I've been working time off in lieu for the last 5 years, haven't been able to find the time to take it. Not only is my annual leave balance huge, my time off in lieu balance is there as well. Are you going to pay that to me in overtime rates? It always causes an argument. So we would recommend that the time off in lieu policy be written, and that policy would set certain conditions under which you can be given, but it must be used within a certain time. And if it isn't, it has to be paid out at the base rate within a 3-month period type of thing. So I suppose I'm all about, and hopefully you guys are in agreement with this, I'm all about reducing the number of transactions and opportunities, because transactions and opportunities is just an opportunity for error. So we can minimise the transactions in overtime situations, in leave loading situations, in time off and lieu situations, then you're a much more effective organisation. Does that make sense?
That sounds good. Thanks, Martin.
Just in relation to just a couple of other things, I suppose, in that regard, it really is dependent. You have to be able to customise, as I say. You can't cookie cutter, and you have to do some different things for your clients. And your clients would really be on about, or having you be on about, doing things that are suitable to them. I want to touch on a couple of other things because there's some sanctions at the moment for underpayments. So I know that there's there may or may not be an election soon, and we may or may not have a change of government. But both sides of government have been talking about the fact that there should be criminal charges for chronic underpayment. And that's been mooted by the Prime Minister recently, and they're talking about jail for employers who are exploiting workers. There are some cases that we can give you as well, and we can certainly include those. But there was one Chinese restaurant situation where people were chronically underpaid, and it turned out to be thousands of dollars. And there were multiple instances. There was a potential finding there of $12,600 per contravention. So it's $63,000 worth of per contravention and a maximum penalty as well. So the organisation could be fined $63,000 per contravention, and there could be hundreds of them. And then the individual could be charged $12,600 per contravention. So at the end of the day, there are some real issues out there. I'll send through some examples of this situation as well. That was one, and there was another Indian restaurant whereby Fair Work talked about, and these are really recent cases, and people were being paid flat hourly rates, and they were just saying, there you go. And in the underpayment to international students, for instance, who held temporary work visas, they were horrendous, and it led them to be paying, back pay of over $50,000. We can afford to do that. Any organisation, small organisation, can't suddenly pay out $50,000 in back pay and then have to pay the fine on top of that. So we really have to be aware of that. This is the small enterprises. There's some bigger ones. Subway, which I know is a franchisee situation, but one of the franchisees was charged and penalised $65,000 because they were paying flat rates again. So they were paying people just a rate, almost paying cash if you like, and so the courts have looked at that and taken a very dim view. On the basis that the number of these unscrupulous behaviours is on the increase, what we're finding is that the government is saying, look, the penalties and the dollar penalties aren't working. As soon as the law changes and someone goes to jail, someone will take notice, and that's not far away. Additionally, in relation to the Vulnerable Workers Act, in 2017, there was a change. We'll send some stuff in relation to that process as well. The last thing that I wanted to talk about was the concept of work experience students and internships. And the reason why I raised that, I don't know whether it's an issue that any of you have as well, but we seem to be engaged on an increasing number of occasions for people to actually say, look, how can I have unpaid people come in and do work? Now, those two things, what's wrong with that sentence? And what's wrong with that sentence is that they're doing work. The tax office and the ombudsman are looking at situations whereby if an individual is engaged to gain some experience, secondary school, year 10, graduates, undergraduates, postgraduates, doing internships, if they're doing work that normally would have been done by someone, it's called a labour replacement and it's actually illegal. If the individual is involved in participating, for instance, there's a series of things. Are they providing services directly to a customer? Are they answering phone calls directly from external callers? Are they profit or gaining from the contribution of that person? And will they participate and attend meetings with clients or others, or other than to observe? Those simple tests, if you pass all of them, you're fine. If you fail one of them, you're not. And so what we are recommending to employers is that if you have a school-based or educational institution-based program, it should be called a work placement, and it can be unpaid because there are circumstances whereby the institution and school will require you as a host to actually provide some experiential existence and opportunities to those individuals. If at any point there is a situation where you failed any of those tests plus another test that I can provide you with as well, then they need to be paid minimum amounts. And you can't just pay them a stipend, $500 at the end type thing. You've actually got to pay them minimum rates. If you don't do that, you are in contravention. So you will either pay up or you'll pay the fine. And the fine recently to one of a small fashion label who was a startup and just thought you were doing the right thing by giving some people some graphic design experience and giving them wonderful experiences as well. This small organisation who only had 5 employees was fined $330,000. Well, they've gone out of business. There's no way they can pay it. But that was simply the fine, and then they had to pay the underpayment of wages. So they would sit there and had to go into bankruptcy. So at the end of the day, these things are really important. I don't raise them to scare you. I raise them to say these are contemporary issues that really need your attention. And if you are in this situation, take it seriously. We've sort of come to the end of the process as well. I'm happy to take some other questions just for 5 minutes or so. But what I will do is I'll send over the next couple of days. It won't be today or tomorrow because I've got my wife's significant birthday, which I shall not mention, on the weekend. And basically, but next week we'll do a summary to you and we'll work through the process and send you some links to frequently asked questions, and we'll address in more detail that superannuation query that was raised. Are there any other last minute questions that you'd like to raise? Number one. And number two, has this been useful?
Kathy has just asked about a recently resigned worker, and the leave loading did not calculate on the final pay when processed. They had already received leave loading for 20 days over the past 6 months. Are they still entitled to leave loading on the annual leave paid in the final pay?
Yeah. Yes. So, at the end of the day, if they've got an entitlement, they've got an entitlement. So, unless there's some quirk of the arrangement, which I don't think there would be, but if it was a stock standard situation, and again, look, I'll put a caveat on all my answers, and only I can say this, it depends. So it does depend on a few things, but at the end of the day, it sounds like she's actually accrued leave, it sounds like the leave was paid out, and it sounds like she wasn't paid what she wanted.
Thanks, Martin. I've got another question here from Anne, that if a business has been sold and later an employee claims underpayment, how would that be handled?
Well, I'd hope that the sale agreement would be would actually talk about that, any of that sort of legacy issue. And I've had a situation recently where we were able to build into the sale agreement a very specific clause that said that any underpayment or any processes, pardon me, for the previous owner, that the vendor would take liability for any of those. So if we were helping the organisation develop the sale agreement, we would make sure that they were, if they were the buyer, we would make sure that the vendor is responsible. It would go down to the sale agreement. In the absence of that, it would be very clear, a court would argue that any underpayment of wages prior to the sale is actually the previous owner's responsibility.
Okay. Teresa?
If, however, just one question, if, however, that employee was given continuity of service and they were given processes, etc., and, there may be some attendant liability with that. So I'm not going to say it's absolutely clear and cut. Most cases, though, it would be yes.
Okay, we've just got a query from Teresa about who we should refer our clients to for HR advice. Well, I can answer that from an AAT perspective, Teresa, that we recommend the AAT HR advice service powered by AB Phillips. And you can find out the details around that subscription on our website under the products tab. So just have a look there, and if you need any more information, please don't hesitate to give us a call. Anne has said further to her comment that this situation is the seller needs to know how to handle this and pay it as it's a totally innocent underpayment. Okay.
Yeah, okay. So look, I would say give us a call and we can assist you with that. I mean, if you are subscribing to AAT, that's the sort of thing we can help you with. You probably need to get your client to engage us to do that. We do that for a couple of hours work. So it's not going to be very costly, but we can review the situation and give them a definitive answer on the circumstances and help them through that process, because problem solving is what we thrive on.
Absolutely. Any further questions there?
I suppose what I wouldn't mind, just from all the people who are there, I don't know how many were there, etc., but I'd love to get some feedback whether this is useful. It's kind of like a conversation. If it's useful, we can do more of it. We can go from there. It's very simple to do, and we can work through making sure that we've got some contemporary examples and follow it up with some frequently answered questions. So if it is something we can do every couple of months, please feed that back to Rochelle. But thank you so much for having me. It's been a pleasure. Hopefully it's been of some use, and we look forward to talking to you very soon.
Okay. Just looking at the Q&As. Yes, very useful. More, please. Yes, very useful. Thanks, Martin. I found it very useful. So, yeah, overwhelmingly, it's been fantastic. Thanks, Martin.
Okay, look, it's an absolute pleasure. And the other thing we want to do is we want to actually lift the collective ability of all of you fantastic people out there who are providing great advice to your clients. It is a community. AAT is a great community of practice, and if we can lift generally, then it's something really good that we're doing for the economy, for employees, for clients. It's just a really good thing to do, and so I really recommend you do the right thing. Hope you have a wonderful, wonderful rest of the day.
Thanks so much for that, Martin. And just in wrapping up, there were some people who couldn't see the questions as they were coming through. So as Martin has mentioned, when he has a chance early next week, he'll put together a FAQ from what has been talked about today. And remember, I'll also send out a link to the recording for you also. So on behalf of AAT, thank you so much for your time and your incredible knowledge today, Martin. It's very much appreciated.
Okay, and look, in the future we might do some polling and some stuff so we can get better at this process as we go through. So happy to help.
Yeah, fantastic. I can set those up, not a problem.
Okay, ciao, bye.
All right, have a wonderful day, everybody. I'll just end the webinar now.